So I just prepared a lot of this morning. The one page from the child's therapy notes, if I could find it myself, page 8. The reason I only included this is because I was only addressing a concern regarding her not accusing herself. And you see a highlighted, or in this case it's low-lighted, about, I don't know, 3/5 down the page, it says Tracy fears dad. That Tracy fears dad is what she told to the doctor. She told that to the doctor. And he signed his name underneath that. And she told him that on February 1st. And that's why, I mean, I do have more notes, and I'd be glad to provide the notes to you. And to help to assist to answer the question regarding the fraudulent claim to the child's therapist.
Apologies, these are notes?
These are the therapist's clinical notes. When she interviewed, excuse me, when he, the doctor, interviewed Tracy Burnson. Now, I don't know if this is an appropriate time to just put this margin note in here.
It's related to that point, it is.
It's actually related to a point that Representative Keynes had brought up that I didn't have a chance to answer, and I don't know if you would like me to supplement. You wanted to know whether or not it was appropriate for me to be making complaints against this Guardian-ad-Litem's conduct, and that you would even feel threatened by that. And so,
would you let her rephrase?
If you could rephrase the question.
I get emails at home right now as a legislator that
oh yeah.
kind of set me on edge.
Oh, I can imagine. You probably
They're
have a lot
not
of
formal complaints through any
agency or
anything like that. So that's,
I guess the answer to that question would be yes, it's absolutely appropriate to, as a self-represented party who is also a party, the actual petitioner in the matter, when he's representing himself, acting in the role of advocate, and I notice that there is a disjointment between the rules and regulations of a particular official's, court-appointed official's conduct, and what the rule and what her conduct is, her conduct and the rules, I would say it's absolutely appropriate to bring that to her attention. And if she uses that as a basis for fear, then perhaps she should be in a different business because she is practicing in a regulated industry.
this, I noticed, did go to her law office.
Correct. Yes.
Did all correspondence go to her office and not?
Yes, she is a one-person law office, and the only email that I have.
Never go home, I mean,
Never. I don't even have her home address. Never have.
Okay. Okay, we're now past point 2 here, making steady progress. Refusing to withdraw, and I will put the word despite in there, conflicts of interest. Or you're saying refusing to withdraw. You pointed out that this has conflicts of interest. Would you describe them to us?
Sure. Well, the conflict of interest really comes to a head on February 1st, 2011, on page 8 of my packet. And I just pointed the committee to the line where the doctor, the psychologist for the child, was told by Tracy that she fears dad. She fears me. So she has a fear of me, which Guardian-ad-Litem Ethics Rule 50306, subparagraph A, I believe it is, says that a guardian-ad-litem shall seek to decline appointment when she has any prior or current relationship, and then it goes on to define what conditions she should withdraw under. That would either favor somebody or disfavor somebody, so on and so forth. And I contend that Tracy fearing me is a relationship, albeit not a very good relationship, but it's a relationship that she has with me that would cause her to prejudice me. She later testified on April 4th, the first day of the 2-day final hearing on parenting, that as she sits in the chair, and I'll demonstrate, she sat there, she goes, She was questioned, do you fear Mr. Youssef? Yes, I do. So, Ms. Burnson, you feel threatened sitting in this chair in this courtroom right now? Yes, I do. I feel a lot of fear. And I might note that at that hearing, there were security officers, there were 15, 20, maybe 30 people, including the gallery, in the courtroom. There's no reason this woman should have felt fear, but she felt fear.
Representative Trumbull?
Thank you, Mr. Chair. I would think that if someone is going to file a stalking order, just there, she should have recused herself. If she felt that she had to go to the police.
You're making a point, but let's
No, but.
stick with questions, though.
That's the question.
That's for our discussion.
And I agree. I agree. Although that would have been kind of a ex post facto or event, but because the stalking order issue came out later. But between the event of her reporting on February 1st, which I'd like to note, February 1st is 10 days before she issued the recommendations. So she noted that she fears me, and then she creates these recommendations that were wholly unlawful and disfavorable. So, with that said, I believe not only did she have a duty to recuse herself, but she actually practiced reprisal. She practiced reprisal by issuing this set of recommendations.
You understand the point, folks?
Yes.
Yeah. Pretty clear? All right, great. Failing to comply with ethical standards and standards of practice for guardians-ad-litem. You have 1, 2, 3, a number of specific points of sort of bullet them?
Well,
Or would they, I mean, you should have, without a storyline, I would just say.
sure.
They can't do this and she did it, they can't do that, she did it, that sort of thing.
Absolutely.
For a starter, I mean.
Well, I have over 40, so I'm not going to list 40, but I will give you a very brief summary of some of the things that this guardian-ad-litem has done against the professional rules of conduct as an attorney, against her own stipulation, and against the guardian-ad-litem 500 series of ethics rules, which are well established by the guardian-ad-litem
We're
board.
talking about in that first sentence, just the part that has to do with ethical standards, standards of practice for guardians-ad-litem. To whatever extent it relates to her, the bar or something.
Okay.
Equivalent to the guardian-ad-litem.
Absolutely. The guardian-ad-litem is, in the petition of Jeffrey O'Ligney, is held to the same standards as an attorney, the professional rules of conduct. Now, and she's an officer of the court as a result of that. Now, as an officer of the court, she has a duty to be forthright and to be honest with the court and to comply with all court orders. Well, she exceeded the court-allotted fees without, there's a fee cap. The court issues a fee cap. Administrative Order 17 states that cap, Superior Court Administrative Order 17, states that that fee cap is $1,000. She filed some motions to exceed, and somewhere in the middle of a motion to exceed, she had a cap, a newly established cap, and she went over that cap without a motion to exceed. That's an officer of the court violating an administrative order.
That's right. Go to the next one.
She,
Was there questions about it?
Yes, you mentioned the petition of Ligney. Is this the Supreme Court in re Ligney or some other case?
yeah, exactly. I think it's captioned petition of Jeffrey O'Ligney, where Mr. O'Ligney, who is a state rep, he wanted to become a guardian-ad-litem.
Okay.
And for whatever reason, the point that I'm illustrating is not the procedural history of the case, but rather the Supreme Court's determination that a guardian-ad-litem is to be held to the same standard of conduct as an attorney under the professional rules of conduct of the New
Were
Hampshire
you
bar.
looking for a number or something like that?
I know there's a case, and I believe that's the one he's referring to, which I happen to be one. I haven't read as many as Mr. Youssef has, but that was one of the few that I've read. So I think that's one.
Yeah, it's a fairly recent case. I don't recall precisely the date, but that is I think we're talking about the same case.
All right, so other points on that. So,
Okay, another violation of an administrative order was Administrative Order 2011-03, which
No, we're
is,
still in the question. You said you had a list of 40 ethical standards violations, and actually, you got one. PCAP, that's it.
sure, she never filed a final report with the
Without
court.
permission. No final report.
No final report.